Really happy to have everyone here. I'm Nancy Drabble, the CEO of Consumer Attorneys of California, and this is Nancy Peverini,
Hello.
the Legislative Director, and we're here to have a conversation as part of a continuing series of conversations with our community about issues and legislation that affects everyone. So I think we'll just start off. Today we're here to talk about the ethics package we had in the legislature this last year. And I think the place to start is to say, why were we doing the ethics package in the first place? When there are many other legislative issues to do, what compelled us to do that package? So, Pev, tell me, what was the origin of the ethics package?
Well, I think there were a number of things, but we saw increasing in the newspapers and elsewhere the legislative attention to ethics issues surrounding lawyers. Mm-hmm. We saw increasing advertising, particularly in the Los Angeles area, and that was actually discussed with us by elected officials who represent public entities, former legislators who are now representing public entities, and we were receiving quite a few complaints about some attorneys, right. And we really felt that it was our obligation and the right thing to do to take a good look at a number of ethics issues. And so I know one of the ones that you worked on was advertising, and of course there's that pesky little First Amendment issue.
Right.
But just to back up a little bit, we did form this committee chaired by Casey Johnson as our ethics chair, and we had a lot of meetings internally.
Yeah, definitely.
To look at all the issues
Yeah.
and look at all the other states. So on the advertising, tell us how you landed on where we did land.
On advertising, it's been such a long-standing controversy, but what we've seen is just such an explosion in advertising, and particularly advertising about specific verdict amounts or advertising awards that people have. So we looked at other states, we looked at Florida, we looked at Texas, we looked at Oregon, a variety of states to see, are there ways to really have something that goes after misleading and deceptive advertising but still is within the First Amendment. So it was hard to try to thread that needle. Ultimately, we did decide to focus on a few different things. In the advertising arena particularly, it was really offensive when people advertise these fake awards that they pay for. And so, in fact, our author, Senator Tom Umberg, the chair of the Judiciary Committee, always told the anecdote that he was a business lawyer. In fact, he's still a practicing lawyer, and he would get a solicitation to have an award as one of the top 15 criminal lawyers in the whole United States.
I get those too, and I'm just an attorney who lobbies. I don't even practice law, but if I pay $100, I could be the top 10 in California.
So that was ridiculous, and we felt like we could deal with that in the bill. So we dealt with that issue. A second issue is people who have no connection to California advertising here. And so we do require that there be a name and an address and a locality that's in California in an ad. And so hopefully that is going to be something that restricts some of the advertisements. So those are two examples.
Right. And I know it really became an issue in the legislature this year as we dealt with legislative attempts to limit legal rights of childhood sex abuse victims and of the victims injured in public entity cases. A lot of the driving force in that push for tort reform was because of some of the distasteful, unethical, and perhaps illegal advertising that we saw. So, of course, the big question is, knowing that there's state bar issues, how will this law be enforced so that it actually is meaningful?
Yeah, so that was another tricky thing. We worked with the state bar and got their technical assistance behind the scene because we wanted to make sure the law would really work, and also the state bar would not feel that anything in the legislation went against the ethics rules or went against what was already in place. So what we ended up with is that if somebody, let's say, sees an advertisement with one of those fake awards, they can report that to the state bar. So we require it to be reported to the state bar. The state bar then has 21 days to say whether that ad is ethical or not ethical. Then after that, let's say it's not ethical, the state bar will tell the lawyer, take that ad down. And they have a short period of time to take it down. If they do take it down, that's it. But if they don't take it down, then there's a private right of action by whoever complained about the ad in the first place to sue that lawyer and recover statutory damages. But there is this process that people will need to go through to complain about the ads, and we hope that that process will really be used. So we're encouraging all of our members to complain to the state bar. If you see an ad that you think is illegal, please report it to the state bar, and they will act within 21 days about that ad. So that's one part of it.
And when does that go into effect, Nancy?
So that goes into effect January 1st.
Okay, perfect.
And so we will see what type of activity there is after January 1st.
Great. Was there anything done in the legislation related to case connectors or those types of issues?
Yeah, that was another.
Maybe explain what those are for, I think everybody knows what they
Yeah,
are, our
so
audience, but maybe not.
I think so. So everybody knows that there's so many lead generators ads out there. And many of these lead generator ads, they don't identify a law firm. They don't identify what state they're from.
Oh, I get so many of them.
I know.
Once I started working on this legislation,
Me too.
every single pop-up is,
Yeah.
I have 24 hours to sign up with them because
Right.
there's a program that's expiring and I can get $100,000 next week.
Exactly. And so same here. And so I started clicking on all the links on those ads. And then you keep clicking, and you never get to an actual law firm.
Right.
And in California, you are not supposed to be advertising that way unless you fall within one of three categories. Either you're a law firm, in which case you should be identifying your law firm.
Right.
Second, if you are part of a joint advertising co-op where somebody can join with other advertisers and other lawyers, but they have rules that they have to follow under the state bar. And the third category is if you're a certified referral service. And mainly we see those with the local bar associations. So if you're not within one of those three permitted categories, you shouldn't be sending ads. So on that, we have made it clear that in order to be legal, we will permit a private right of action if somebody is engaging in this behavior and if they are violating the current law.
Right. And as an aside, your husband is a former constitutional law professor because he was my constitutional law professor at McGeorge. So I'm sure you had some interesting conversations at home about the First Amendment and what we could or could not do in California.
Yes, that's very true. And so my husband and I talked, and I would tell him we really want to go as far as we possibly can within the purview of the First Amendment. And he was telling me, you can only go so far, because it is the First Amendment. We do all care about that, and we don't want a constitutional challenge to the legislation. So we did as much as we could.
Right, right. And were there other key provisions in SB 37?
So the last really important part of the bill is we create a private right of action against cappers. And as we know, capping, which is paying for cases, is already a criminal offense. It's illegal under the Business and Professions Code. We don't think it happens that often, but when it does, that is repellent. It is so wrong.
And of course, there's been recent LA Times stories about a particular firm, the DTLA firm in Los Angeles, who has been accused of capping in childhood sex abuse cases. So it really is a terrible thing. And I think a great thing about what consumer attorneys did was as soon as that story came out, we not only had our legislation in front of the governor dealing with capping, but we wrote a very strong letter to the state bar asking for an audit and an investigation. So I'm really proud that our organization, as always, stepped up and did the right thing.
Yeah,
so.
And we hope this will create effective enforcement against capping because, as you know, the DAs, they don't typically have room to bring cases against capping when they're prosecuting murderers and rapists. So it's
Exactly.
really far down on that priority list. So this should provide some effective private enforcement. So those were the main provisions of SB 37, which was carried by Senator Tom Umberg. So let's turn our attention to the other ethics bill, which was 931, AB 931, carried by Assembly Judiciary Chair Ash Kalra. And tell us a little bit about the issue of the consumer legal funding and what we were addressing there.
Right. So this bill tried to address and did address non-recourse advances to plaintiffs. So this is not litigation funding to law firms, but there was zero regulation in the state of California related to non-recourse advances to plaintiffs or consumer litigation funding. And a couple of years ago, the insurance industry came in and had an attack on these types of contracts, but the attack was really aimed at lawyers because they sponsored legislation carried by Senator Ana Caballero from the Salinas area to force disclosure of those contracts by plaintiffs' lawyers to all defense attorneys. So in effect, and this is something, of course, we, as CAOC, opposed,
Right.
there would have been every single time a plaintiff got one of these advances, and they do serve a legitimate purpose because
Right.
oftentimes, court process can take several years.
Right.
Low-income people in particular may need to pay mortgages, pay their rent.
Yeah.
They serve a very useful purpose in making sure that people can stay afloat
Yeah.
during their litigation. On the other hand, to require disclosure of those contracts to the defense lawyers would certainly give defendants and their attorneys a leg up, a way to use that loan.
Yeah, it's really none of their business.
It's none of their business. It's a private contract. But there was a serious attempt by the insurance industry to do that, so we defeated it. But as we looked further into the issue and we realized that, there are some things that, there's some unsavory stuff going on out there.
Definitely.
And what we saw was that there were some of these contracts, they weren't clear. They had terrible, interest rates and hidden charges.
Yeah.
And then, again, we love our profession, but not everybody's the same.
Right.
There were some lawyers that had financial interests in these advanced lending firms, and they were steering clients to a loan plan that they had a familial or financial interest in.
Yeah.
And so we decided to be proactive and really make sure that these worked as they should and that there was regulation. So that's why that part of AB 931 was sponsored.
Yes. And that will go into effect on January 1st also.
Yeah, and so it's great. It has such benefits for the people who take these loans. They have to have clear terms in the contract. It has to be in the language in which it was negotiated. We had people who didn't even know what they were signing because these contracts would be negotiated in a language. They'd be given an English contract. They'd sign it, and then they'd end up paying so much money for these advances. The law will now require a 5-day right to cancel, and all of the terms, including the full and total amount that has to be paid, will be specifically detailed in the contract.
Yeah.
So that was really good. And then on the attorney part of it, attorneys can't have an interest in one of these companies and steer clients to it. The companies can't, what we would call poach, I guess. If somebody already has an attorney, they can't say, come to this other attorney and you could get a loan. And so there's really a lot of great consumer protections. I would say for our lawyers, they should read the statute. There's new requirements on them on what they can and can't do. Some of them were already the practice and we think the law, but now it's clear that, for example, one of these companies can't have a say in the settlement.
Oh, definitely
that
not.
type of thing.
Yeah.
So it's really a productive, and I would say we worked with the lenders to try and make sure that it worked for the good lenders that we work with, that they can comply with it. But I think it's a really good statute, and it's, it's first in the nation as far as this type of statute.
So now we really have a comprehensive regulatory scheme for these consumer non-recourse advances.
Yes.
So we are proud of that.
We're very proud of it.
Yeah. Yeah.
First in the nation. And then as the insurance industry keeps pushing, as they even did last year, for disclosure of the contracts, we will continue to oppose that. And we, of course, can point to our new legislation and say, look, we now have new regulation of this practice in the state of California. It's thorough, it's very consumer-oriented. There is no legitimate reason to require plaintiffs to disclose these to the defense counsel.
And we are still anticipating a push by the insurance industry to get disclosure of litigation funding to law firms. And that's something that we have opposed because, again, it's not their business whether a law firm gets money from a bank, from a litigation funder. They just want to know that to get a tactical advantage, which is unfair.
Right.
And they want to know, can this law firm last 1 year, 2 years in trying to pursue this complicated legislation? So we will continue to aggressively oppose that.
Right. And it's also an issue, unfortunately, on the federal level. Our partners are at AAJ and are working on the federal level, but it is absolutely true that the insurers, particularly one particular trade association, APCIA, will be back this year with legislation on that, which we will oppose.
Yeah. Never a dull moment.
Yes.
Yeah, always something going on.
Right. And there was another part to our bill, too, that you and Savina Takar took, or you and Jackie Cerna took lead on.
Actually, all three of us had to work on it at various points because it was so controversial. And
we call it the ABS, but maybe you could explain what.
Yeah, so this really goes back to a few years ago when the State Bar of California had the not-so-good idea of allowing non-lawyers or even apps or tech companies to practice law without being a licensed lawyer. And it was really that they had, at that time, stars in their eyes about, it's going to somehow improve access to justice. So we worked with groups, particularly in legal aid and other allies, to stop that very misguided state bar effort, and ultimately there was language put in the state bar dues bill to say no, they can't explore having non-lawyers practice law because that goes against everything we know as lawyers to have a fiduciary duty to your client.
And Nancy, did you have a little hand in getting that done?
Just a tiny bit.
I bet you did.
And then, but like a zombie, it was rising, and they did decide in Arizona to basically have it be wide open. And they have what is called alternative business structures in Arizona, where some company can apply and they can start to offer legal services. All they need is one lawyer as a compliance lawyer, and they have to follow some fairly minor regulations. And so in Arizona, there are over 100 of these alternative business structures. But one of the things that we saw in the intervening time since we stopped the state bar from doing this back in, I think it was 2022, is we were seeing hedge funds and private equity come into Arizona and own these companies either wholly or partially. And then they have these profit-making entities, which aren't really law firms, and then they were attempting to share fees with California lawyers directly. And as all of our lawyers know, it is unethical to share fees with non-lawyers.
Right.
You can't share a fee directly with a tow truck driver or some other company. That is unethical.
And prohibited in the state bar rules.
We felt it was prohibited in the state bar rules, but at the same time, we felt it was necessary to go further than the rules because it wasn't specifically addressed. And so we wrote language in AB 931 to make it crystal clear that you cannot share fees with non-lawyers. And so as you might imagine, some of the Arizona alternative business structure companies were not too happy about our legislation, and so they formed a fake front group to oppose it. Eventually, we were able to overcome that opposition. We took some amendments, and we were able to move the bill. But it's a very strong bill. Again, first in the nation. It's gotten a lot of attention nationally in Reuters, Bloomberg, various places. And that will go into effect on January 1st also.
Right. And I know as we collectively lobbied this bill,
Yeah.
they portrayed our bill as, against people who might need legal services and
Right.
could not afford them. And by forming that fake group,
Yeah.
it was very polished, but they
Yeah.
did, get some random, coalition groups
Yeah.
that sounded good on paper who really weren't even groups because we tried calling them and they didn't have phone numbers.
Right.
But it was somewhat difficult to explain how this was really helping all
Right.
people with access to justice and not an attempt at all to protect our own.
Right. And in fact, we had allies among the real legal services groups,
Right.
like Western Center on Law and Poverty and other legal aid groups, because what they see in their practice is they see people come in who aren't getting help from real lawyers, whether it's in immigration or in tenants' rights, and then when they finally come in, if they haven't been talking to a real lawyer, then the legal aid lawyers are trying to clean up the horrible mess. And
Right.
sometimes people have already lost all their money or they've been evicted. And so legal aid is very sensitive to having people who are eligible for legal aid get high quality legal help, and they shouldn't be second-class citizens.
Or scammed,
Or scammed.
right? Because
Yeah.
I think a lot of people
Yeah.
are easily scammed by,
Right.
the promise of false good legal services when
Yeah.
it's not.
So, in wrapping up this podcast, Pev, we've worked on these ethics issues this year. It was quite a winding path, but it was very successful. It's quite possible we're going to be doing some additional ethics issues next year, but we'll leave
I
that
hope
for
we do.
another chat.
We do want people's ideas.
We do want people's ideas, but thank you for having this conversation
Yeah.
today. We love to have our members' involvement. And if you have ideas for legislation, if you would like to participate, please be in touch. We are always ready to answer your calls, answer your emails, and we want to know what you would like us to do in the legislature.
And thank you. We appreciate
Thanks.
everyone's support. So, thank you.